Yes, welcome to the No State Project live from my fortified compound in Mesa, Arizona, where it is an ungodly 111 degrees here in the valley. It is, wow. So, yeah, we are at that stage where it's going to be 110 plus until we hit September. So we're going to get July, August, and September. Yeah, we're going to have 3 months. So, I don't know how much longer I can do that. I love Arizona, but there's a lot cooler places like Strawberry, Payson area, Pine, a lot cooler. But I appreciate everyone as you start to file into the stream. You can go to Mark Stevens NSP or look at the link in the description for the Discord. I know life is busy. I'm trying. I'd like to get the calls, so maybe for the Wednesday or the next Monday broadcast, if I am doing a broadcast next Monday, I forget when the holiday is, when no one's going to be tuning in anyway. But if you want to help support the channel, so I could do more streams, then you could do so in the description. The links are in the description there. And this is a request from Calvin, who unfortunately is not able to join me again. Hopefully we get Calvin back on the show, on the stream again real soon. But a couple streams ago, I did all about a cause of action, what a cause of action is, which again, very, very simple. It is the violation of legal right or known duty that results in loss, harm, or injury. And of course, there has to be jurisdiction. Those are the elements, of the basic elements. The loss, the breach of a legal duty, the damage, and jurisdiction. And so Calvin had asked that I discuss again. It's been a while, and it's all, you go into the description, you get an ebook directly from me, government indicted, and I go through a lot more detail in there than I'm able to do today. But the difference between a civil case or cause of action and a criminal one. So I discussed mainly the civil side last time. So I want to go in and talk about the differences in criminal, like a criminal case. So a crime is still the violation of a known legal duty that results in loss, harm, or injury. So that's the same thing. A big difference is who has standing to bring the actual complaint. In criminal law, only the government there, under the pseudonym, the state. Or if you're in Canada, the Crown. I think they do that in Australia also, where if you go into my YouTube channel here, and you look up tickets dismissed, you'll see we got a lot of stuff thrown out against the so-called Crown over there down under, eh? But definitely, yeah, if you, so let's see, I will go to this, go to my channel, and I want to search across my channel. Oh, you could just type in Mark Stevens too. So you got that there, you just type in tickets dismissed. And not all of these were criminal. A lot of them were, but not all of them are. And you get this really long list of tickets getting thrown out and the proof there. And so you go through this list. Again, I had markstevens.net, which I don't have anymore. I couldn't afford to do that anymore. And after 2020 decimated me, and a lot of us, where I had the actual copies of the documents there. Oh, here we go. Ticket dismissed down in Australia. No evidence to offer there. That was more of a Boston than Aussie, but yeah, y'all get that day. You get it. So that's one of quite a few that we did have thrown out in Australia. You can see the evidence is right there. 99% of the time I posted that I did have something tossed out. I think it was, or maybe 100% of the time, I always had the documentation to actually prove it. So Yes, and yes, I'm aware that there are critics that say I and no one else has ever had any success whatsoever. The proof is, but you can look at the damn proof right over there. That's just one. That's just a straight. Anyway, so that's one of the main differences is that between civil and criminal, and that doesn't mean that a criminal prosecution can't be brought, a civil prosecution can't be brought by an attorney general or a state. They do that all the time also. But for crimes, only the government there, under the pseudonym of the state or the federal government, the United States or the Crown, can bring a criminal proceeding. And in a criminal proceeding, typically, like at the federal level, United States federal level, whether it's misdemeanor or felony, that's your breakdown there of the criminal charges. It's either a felony, a grade of felony, or misdemeanor, or a petty offense, depending on where you happen to be. So whether it's a misdemeanor or a felony at the federal level, has to still be by a grand jury. So criminal complaints at the federal level, always grand jury. If you're at the state level, it could be either by a grand jury or it could be done by a complaint based on showing a probable cause by the prosecution, by a prosecutor, a state attorney. And I will point out my favorite prosecutor. It should come up. Larry mother effing Krasner. Love this guy. Love this guy. 9 innocent people exonerated because of this guy right here. So as the district attorney of Philadelphia, he's the one that has the authority. He's the one that brings criminal complaints. In the name of the Commonwealth, it's Commonwealth in California, in Pennsylvania. So those are two differences. Another difference in the civil and criminal is the burden of proof. The burden of proof in a civil complaint, except for jurisdiction, both sides have a burden of proof. But if Larry Krasner, for example, if a prosecutor in a criminal case, if a prosecutor brings a criminal proceeding, whether by complaint, an information, or by an information by a grand jury indictment, the burden of proof is beyond a reasonable doubt, and the defendant does not have a burden of proof. The defendant in a criminal proceeding has, if it's me, I have no obligation whatsoever to put on a case. So after the prosecution rests, I don't have to put on anything. I don't have to do anything. But in a civil proceeding, if the plaintiff's attorney has put on evidence and has testimony and witnesses and documents and what, then then the burden of proof shifts to me as the defendant to overcome that. So it's by preponderance of the evidence in a civil proceeding where the judge or the jury is going to weigh the evidence there. And I know it's kind of split. In a civil proceeding, if there's a trial by jury, then it just has to be a majority vote of the jury. So if it's 12, 7 takes it. And in most jurisdictions, the jury in a criminal proceeding has to be unanimous, which I think is just, that is one of the best parts of the American justice system, is that there has to be a unanimous verdict. Now, there are some states where it's not, and I would not want to be on trial there. So if the federal level, for example, you're in Arizona where it has to be unanimous to convict someone of a crime, if not everybody agrees, they can just declare a mistrial, and then, they call it a hung jury. So that is a really, I think the unanimous decision, criminal, that is really good. In some states trying to change it so that the criminal is just by a simple majority. Yeah, I'm not too happy with something like that. So you look here again. I like Wiki because it is footnoted. These things are footnoted. It's not just some idiot typing out at the computer and doing it. It's footnoted, and this stuff can be. And we should have some, media literacy and independently verify this stuff. Now, I've done all this verification in Government Indicted, and if we go to my shows, my channel here, I've done it plenty of times. So this is not something that is new to anybody who is a long time watcher of the show or listener to the podcast. Criminal cases usually place the burden of proof on the prosecutor. Expressed in a Latin, I probably shouldn't do the Latin. It's worse than my Italian. The burden of proof rests on who asserts, not on who denies. The principle is known as the presumption of innocence. See, the judge and jury in a criminal proceeding have to maintain a presumption of innocence. Now, I know. The judge, especially in traffic and tax prosecutions, they're assuming an awful lot there. That's not my purpose necessarily to get into today. I can't do a full. I go another 15, 20 minutes. It's summed up with the innocent until proven guilty, but it is not upheld in all legal systems or jurisdictions, but I'm talking about the United States. Where it is upheld, the accused will be found not guilty if this burden is not sufficiently shown by the prosecution. The presumption of innocence means three things. With respect to the critical facts of a case, the defendant has no burden of proof whatsoever. See, that's one of the reasons why I think why we've had so much success, regardless of what these disgusting critics say. I mean, my gosh, how many, I don't know, it doesn't say how many are in the search here, but it goes on for pages to say, well, yeah, I like ones when you have absolute proof of success. Well, it was just traffic. Doesn't even count. Yeah, okay. All right. I lost. Oh, I credit it with the fact that I take this very, very serious. So if I'm able to knock out the foundation of the prosecutor's case and show that they have not even come close to meeting their burden of proof, obviously there's no reason for me to put on a case. The state must prove the critical facts of the case to the appropriate level of certainty. That's why we've been so successful here, as you could see. So many damn tickets thrown out because the prosecution has to prove the critical facts of the case to, beyond a reasonable doubt. Now, remember, in tax cases and traffic, the main evidence is in the form of testimony from the agent and the cop. Let's say a traffic ticket. It's the cop. The critical facts are proving his main allegation that he saw me in Arizona, the laws apply, and I violated them. Those are the critical facts that on cross-examination, they are not able to prove. So again, like I've mentioned before, which is why we've been so successful, especially before, even having a trial, is getting the cop to restate his testimony and what his actual claim is under oath, on cross-examination, and then just asking for the critical facts, asking for the evidence. And again, we know the routine. The prosecutor objects, calls for legal conclusion, even though the question we're only asking for facts. The jury is not to draw any inferences adverse to the defendant from the fact that he has been charged with a crime and is present in court facing the charges against him. This is a big deal. And it's one of the big differences between a civil proceeding and a criminal proceeding. Because in a civil proceeding, if the defendant refuses to testify, then the jury is allowed to draw an adverse inference. So that is big. So, for example, that orange scumbag, Donald Trump, didn't testify in the defamation suit against him, that he wound up losing bigly. I mean, numbers nobody has ever seen. Everyone's talking about it. In that particular situation, that he lost bigly, the judge and jury, or the jury rather, was able to draw an adverse or a negative inference. The fact that he did not testify, they were able to take that as proof that what the defendant, what the plaintiff had, and the plaintiff's witnesses had testified to were true. That he did defame her. And of course, they found against him. So this is a really, really big one in the difference between civil and criminal. Another really, really big difference is excluding things like contempt, which is kind of an extraordinary thing in the civil proceeding. But in the regular course of civil proceedings, there's no jail time. Now, yes, you can be held and put in jail for contempt, but a conviction doesn't carry with it any jail time. So a crime is beyond a reasonable doubt. What I just discussed here, the burden of proof is on the prosecutor to do that. It's brought in the name of the state or by a government agency, and there's jail time. And, there's also the whole grand jury. So those are really the big ones. I'm not going to get into all the procedural things that are involved because that would take, a couple of hours just to kind of scratch the surface. But those are the big ones. And it's important to know because if I'm going into, this is all about me. If I'm going to go into a proceeding and I understand that I don't have a burden of proof, that doesn't mean I'm not going to actively defend myself, but it does, in my experience, what I've done is to focus my attention really on knocking out the foundation of the prosecutor's case. Again, it makes it really easy, and it's easier to really focus on that when we're dealing with a traffic ticket, because traffic tickets, there's not much, you don't have much skin in the game there. Yes, you can go to jail, but it's not like you're going to go to prison, and it's not like you're going to go for 25 or 30 years. The stakes are usually much lower in traffic. Usually in traffic, you could just throw money at the situation and you can walk away. But it's easier to focus on the fact that there's usually only one witness, just one. So my discovery, my initial defense is going to be focusing on, is this witness? Now, Rule 602 of the Rules of Evidence, the Rules of Evidence generally apply to civil and criminal. And Rule 602, if it's the federal and like Arizona, if the state has adopted the federal rules, Rule 602 has to do with the competency of a witness. And I probably should have had that up already, but it should come up pretty... I've looked that up so many times. A witness may testify to a matter if evidence is introduced sufficient to support a finding that the witness has personal knowledge of the matter, which is why I'm asking in this, I moved to dismiss because the witness, the police officer, does not have such evidence, which if I'm forced to go to trial, it's going to come out that the prosecutor will agree with me, and the prosecutor is required to give exculpatory evidence. And this is really important. It's called Brady material in a criminal proceeding. That if there's evidence or there's information that tends to show I'm innocent, which would, I believe, include that a witness does not have evidence to support a finding that they have personal knowledge of the matter, that the laws apply because I'm physically in Arizona. If he doesn't have personal knowledge of that, he can't testify to it. And if he has testified to it, it should be stricken in order to be fair. So if The prosecution, when I've done my motion to dismiss and I've done a motion, and I've moved for certain parts of discovery, I want the evidence the officer is planning to use, and what the prosecution offers, and what the witness is going to testify to. I want to know the evidence that they're planning to present, which is part of discovery. And if the prosecution can't give me that, if they can't establish that the witness has personal knowledge, then the witness is not permitted to testify under Rule 602. Very important here. And what's important to remember is why we've been successful is because the prosecution doesn't have such evidence. The prosecution's witness doesn't have personal knowledge of that. So they're going to put them on the stand anyway, and they're going to agree with me when I ask them for the facts to support that legal conclusion that they've made that's on the ticket. Objection calls for a legal conclusion the witness can't testify. I've heard it 100 times more in court. This is evidence where other people have been able to do that. Oh yeah, I love this. Yeah, it's just a parking ticket. It's just. So always moving the goalposts, right? You've never had any success whatsoever. Well, here's a traffic ticket. Well, it's just traffic. That doesn't actually count. It's not really court. Sure. All right. Whatever the critics and those dumb enough to actually take them seriously want to believe. What can you do? All we can do is present the evidence and let the people decide for themselves. If you're too stupid or you're too lazy, just to do a simple search on my channel to see where the evidence is, it's a big world. Who cares if some people don't? But that's what we have to do. You know, that's something you have to expect. My gosh, we really got a lot of stuff thrown out. Got a lot of stuff tossed out. That is pretty cool. So, all right. So those are the main difference. I'm going to have to cut this off here. Not the last time I'm going to talk about this stuff. Not the last time. So what I want to do is I want to get to the comments before I have to go. So I'm going to... Hopefully that triggers some people. I know I might lose a handful of viewers, but who cares? So let me see what we've got here. Aloha, mahalo. How about talking about legal maxims? Here's a legal maxim to always keep in mind when dealing with government types and trying to understand why they do what they do with no reference whatsoever, especially judges. And it is necessitas non habet legem. Some pretty impressive Latin there. Necessitas non habet legem. And what that means is necessity has no law. Now, I understand about, if things happen, maybe something has to be torn down to keep a fire from spreading because it was necessary. But I think these government types take that to an extreme level. Just like you're supposed to be entitled to a fair trial, which includes a judge who's not inherently biased against you. And they turn around and they say, if you can show that all the judges are biased, then of necessity, then none of them are biased. So if they all are biased against you, instead of just saying, you're going to have an unfair trial, and somehow try to work the mental gymnastics out to justify having a trial in front of a judge who is biased against you, who is actually not going to hold the prosecution to their burden of proof. Because, we're all biased against you, Mark, which means none of them are. I don't have the court case that, offhand. It's in government indicted, but that's an actual ruling. Well, if you disqualify them all, then you disqualify none. Necessitas non habet legem. So that's one of them there. Legal maxims. Zubrooks AB, you should probably abstain from using the Australian accent in front of decent company. Was it really? All right. You probably got a point there. I haven't done it in a while, but it's usually pretty good. If people were truly presumed innocent until proven guilty, they would never be able to be forced into court in the first place? Well, I know, because from a strictly legal standpoint, that there's probable cause, and that's something that, in criminal proceedings, there's probable cause. There has to be at least the legal principle. I'm not necessarily every time in practice, but in principle, you're not supposed to be put on trial unless there's probable cause. So I would disagree there. Much love. Yep. What's the word for the opposite? Oh, inculpatory. I believe that's what it is, where it's actually evidence of guilt. World War Wit. How is that any different than the legislator declaring someone guilty of liabilities and duties by fiat than the prosecutors unable to prove it? Well, legislators are actually, at least at the federal level, are not supposed to be able to declare guilt, because that would be a bill of attainder. But they do it all the time in their statutes. Well, hey, come on. Ben Affleck called. He wants his accent back. Hey, all right. I'll back off for the Aussie today. You don't have to be guilty to be arrested. You have to be presumed. You have to. There has to be probable cause. So there has to be reasonable, articulable suspicion. U.S. versus Terry, going back to like 1969. Is that what that is? I'm trying to remember. U.S. v. Terry. Oh, come on, I didn't want that. There's actually a Terry versus United States in 2021. Oh, 1968. Terry versus Ohio. So that's where we get the Terry search from. Under the Fourth Amendment of the U.S. Constitution, a police officer may stop a suspect on the street and frisk him or her without probable cause to arrest if the police officer has reasonable suspicion that the person is committing, or is about to commit a crime, and has reasonable belief that the person may be armed and presently dangerous. That's Terry versus Ohio, 392 U.S. 1 and 1968. So, big time case they teach in law school and other law type of degrees. Terry versus United States, that is a big one. So they have to have reasonable articulable suspicion, and then to arrest you, there has to be probable cause, which is a higher legal standard there than so. Let me go back to the comments here. Yeah, Ben F. I think a more apt would be that maybe comparing it to. Maybe was it really as bad as Dick Van Dyke in Mary Poppins? Was it? U.S. versus Bailey. Yes, that is actually in detail in Government Indicted. That the ticket is not the actual evidence. The ticket is supposed to, or the complaint sets forth the evidence. Just like when I went through the 49-page indictment of the twice impeached, twice indicted, disgraced former President Donald Trump. All right, I'll finish on this because crime against two. A civil proceeding is considered that it's loss, harm, or injury against an individual or a small group of individuals or a company, a person, whereas a crime is considered a wrong or an injury against society. So I planned on discussing that, so I'm glad that was brought in, and that, yes, the damage or the injury cannot be hypothetical. It's not supposed to be hypothetical. That is a big one. So World War Wit, I'm glad you brought that up, because that is an important distinction between a tort and a crime. In fact, I can't believe I didn't use the word tort at the beginning, because that's how do you separate a tort from a crime? And it's brought by the state, there's jail time involved, and it's considered a wrong or breach of a duty that results in injury to the community at large, or the state so-called. But yes. So thanks for bringing that up, World War Wit. I am out of time. I'm getting the message there. My camera's going to die. If you would like to help, so I could do a longer stream or maybe more streams in general, you can do so in the description. Go to Mark Stevens NSP. Well, the link is in there for the Discord, and I promise I will get a call-in show back again real soon. I'm looking for, I really want to do that. I do want to do that. I do miss the interaction. I want to do that. So if you get any value out of the information presented here on the stream, let me know in the comments, or if you have any ideas or any other topics you want me to discuss, let me know in the comments. And you go in the description, you can help support the channel that way. Just like you don't have to see me doing editing on the fly if I get another monitor. But if I could plug my camera in, I wouldn't be limited to the battery time. So much love to everyone who tuned in, and to those who watch the stream later. I will be back on the Wednesday broadcast, same time as Arizona time, 7 p.m. I guess that's 10 p.m. on the East Coast, and 6 p.m. if you're on the West Coast. So I will end there. And one topic would be, if officers swear oaths on the penalty, why are they never prosecuted for violation of the oath? That is a very rare thing where they're prosecuted for that. I don't know if it's for that directly, but that is something I can't get into right now. But I do appreciate everyone tuning in. Until next Wednesday, when we can be together again, salud.